Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Yesterday, as I was sitting on my couch at my house in Florida, I came across an interesting query on Quora. And here's what it asked. It said, "My husband threatens that if I divorce him, he will quit working or find a lower paying job so I don't get any alimony. Can he really do this?" Well, that was an interesting question. But what was even more interesting were some of the answers. Like, for example, this one. Yes, yes, and yes. Your husband, just to spite you, will get a lower paying job so you can be miserable. The judge can't make him get a higher paying job to pay you a high alimony payments. Minimum wages in most states start at $15 an hour. Some are less depending on the industry. He can, on purpose, pick the lower paying job, rent a room, just to keep you from getting more. Are you willing to spend time in and out of court getting judgments for non-alimony payment? Good luck getting it at that approach and chasing him back to pay alimony. Why would you want to be blackmailed just to make you stay? You don't want the marriage. Take a leap of faith and divorce him. Not sure what your work background is, but you can work and make your own money. Now, I'm not sure who the person is who answered this in this way. Her qualifications were property owner. I'm not really sure how that qualifies her to be an expert on things like alimony and child support. But I will say that I found the answer very interesting, and I wondered if perhaps it was her husband answering her query on Quora with a different name, which sort of sounds like something that somebody might do in Hollywood. Anyway, now that you've heard the worst possible answer on Quora, here is the real answer. No, your spouse can't pick a low-wage job and deprive you or your child of child support or alimony if you're entitled under your state's laws. Now, back in the waning days of the 1950s, alimony was almost a rite of passage for women who were getting divorced by their husbands so that the hubby could go and get himself a trophy wife. Men who were high-wage earners were often saddled with alimony until the spouse remarried or died. In Missouri, one of the judges I used to work for on the Supreme Court, when I worked there, referred to how men escaped alimony as a St. Charles divorce. This generally meant that the husband called the "till death do us part" clause into effect. But as more and more women entered the workforce, as feminism took hold, and women were told that they were just as entitled to those high-wage jobs as men, and as educational opportunities increased for women to enable entry into those professional relationships, alimony, or sometimes that's called separate maintenance, slowly started to wane, and they started to look instead at whether or not the spouse was capable of working, had been trained to work, had a career of her own, that sort of thing. Now, even where it's granted, it's often referred to as modifiable maintenance because many times wives do go back to work, and if they do, it isn't fair to make a spouse continue to pay for his ex-wife if indeed she has gone back to work. In many states, alimony is only granted where there's a one-wage earner family. If the husband works for Giganto Megabank making $450,000 a year, and the wife stays home, keeps the children, and the home fire's burning for 20 years, her ability to enter the job market after a divorce is severely limited by virtue of not having worked. So quite naturally, alimony is proper in that instance because otherwise she might not be able to house or feed herself or take care of the children. If you can't take care of yourself, you can't take care of your kids. But some states condition alimony on a reasonable period. So when Barbie marries Ken at age 19 and at age 29 divorces Ken, when he's making $300,000 a year, it may be reasonable to pay her maintenance only for a period of 3 to 5 years to enable her to finish her college degree or get job training. And these are the kinds of things that divorce attorneys fight over all the time. Child support, however, is another thing. Child support is both a legal and a moral obligation. If you fathered them or you mothered them, you're responsible for them. You need to pay to keep them fed and clothed and educated. You need to make plans to ensure that they can go to college. You might not have to pay alimony if the other spouse can work or has a job, but you will have to pay child support. Now, in Missouri, as I think in many other states, we have a form. In Missouri, it's called Form 14, which requires all of the parents' income and expenses to be listed. And we have discovery rules that make it difficult to hide income. Spouses' income taxes will need to be produced. Wage and earning statements are subject to discovery. Bank accounts and bank records, 401k records. Hiding assets is a sure way to get sanctioned, as there are specialists at locating assets. And you may think you can get by with ditching $100,000 in some bank in another state, but it can be found and it will be. The spouse's incomes are combined and a percentage is determined as to which is larger and what percent that is. Then child support is determined based on the income amounts, and in some states the amount can be staggeringly high, almost confiscatory. But courts will need to see some real evidence before they go outside the form calculations in Missouri, and I would expect in other states as well. It is the well-being of the children that's at issue with child support, and just because you pay child support doesn't mean you're off the hook for other things that aren't covered by child support. If Junior needs braces and you have 60% of the income, you're going to pay 60% of those braces. If Junior needs books for school, you're going to pay 60% of those as well. Hey, allow me to interrupt for just a second and ask you, if you haven't already subscribed, please subscribe. And if you wouldn't mind, hit that like button. That lets YouTube know that this is a good video and they can recommend it to others. It helps me out a lot. Thanks. Sometimes child support can seem like the never-ending story. So in that circumstance, many people try to get out of these obligations by reducing their income. Here's what happened to one fellow who thought that reducing his income was a good idea. At around the time of the separation, the husband changed his employment, and at trial he testified that he was no longer willing to work multiple jobs, and in this case that's because he worked at a car dealership selling cars, and then on his off hours he had a lawn care service, and he did a lot of other things generally to earn money. And he did that over the course of about 20 years. So he said he was no longer willing to work multiple jobs to support his wife and children. Even though the husband testified he was going to sell his lawn care business to the father, the trial court found that he would continue to receive substantial income from this business and found that his father's running of the business might be temporary based on prior times when the husband had changed jobs. The trial court found husband to be intentionally underemployed and imputed income to him at $8,000 per month. The trial court found that the Form 14 presumed child support amount was $2,252 per month. The court found that that amount was not unjust and it wasn't inappropriate, and he ordered the support to be paid by the husband to the wife in that amount. The trial court also found that the wife was not able to support herself based on her limited education and her work experience, as well as her responsibility to care for 6 small children and homeschool them. And it found that husband had the ability to provide maintenance to wife and ordered modifiable maintenance in the amount of $1,700 per month. Then they fought over the income of that came from the home. The wife valued it at $179,000 and the husband valued it at $240,000, and he wanted the house. The trial court found it was valued at $179,000 and subject to a mortgage of $78,675, and the home was awarded to the wife, as well as the obligation to pay the mortgage on the house. So the husband lost at pretty much every turn there, and as you might expect, he appealed. So the husband appealed, and here's what the appellate court said. Husband's first point on the appeal is that the trial court erred in imputing income to husband for purposes of calculating child support because husband was not unemployed or underemployed and did not voluntarily reduce his income to evade parental responsibilities. We disagree. Anytime that's the first paragraph in point 1, you're not going to do real well. The husband claimed that there shouldn't have been any imputation of any income at all. So the appellate court said, the theory behind imputing income to a spouse or parent is directed at preventing a spouse from escaping responsibilities to the family by deliberately or voluntarily reducing his or her income. And then they cited a case called Cross versus Cross. Imputation of income is proper where a parent has voluntarily reduced his or her income without justification. And justification might be you broke a leg, you got sick, you couldn't do something. But just decide you didn't want to work that hard, that's not going to fly. The most common scenario for voluntary reduction of income without justification is where a parent deliberately quits work to reduce his or her child support obligation. So in Missouri, as in many other states, you can't just quit working and expect to pay no child support or alimony. In Missouri, if you have a professional license, it can be suspended if you don't pay your child support. If you do that, you can be subject to jail for contempt of court. If you have a bank account or a savings account, the court can garnish the bank accounts. They can garnish your income. They can garnish your wages. There are lots of things that can be done to enforce both child support and maintenance. Now, every now and then, a particularly loathsome character will simply skip town, drop off the grid, never to again appear in court, and it can indeed be hard to obtain support and alimony from someone who is living in a log cabin in the woods and no one knows where he is. But anybody who has a legitimate job somewhere is going to show up on tax records, and he can be found. Skipping out entirely and living in a cabin in the woods, that only works in Hollywood. So, while we were down in Florida, my wife and I had a problem with a fan, a ceiling fan. We had to call an electrician. And our electrician is a really great guy. And one of the things that he does sometimes is he has to bring his daughter with him because he is the sole provider for his daughter. The wife or the mother is nowhere in the picture. And so as a result, she accompanied him, and she's probably, I guess she's about 7 years old. She sat on our floor and played with our dogs and just had a ball. And then as they got ready to leave, she saw our big collection of board games underneath our little table in the main foyer. And she started looking at them and she said, "Oh, I really like this game." Well, it's one I'd never even played. My wife said, "Well, you know, if you'd like that game, we never play that. Why don't you take it with you?" And her father said, "Oh, no, she wasn't asking for the game." I'm like, "Look, we don't care. It's just one less thing to dust. Take it with you." My wife is very kind, and that's one of the many things I love about her. If you have the opportunity to be kind to somebody today, please take a moment and do that. And if you're thinking about skipping out on child support, think again. At any rate, thanks for watching. I hope you found this interesting, useful, helpful, informative. If you have any questions, leave them in the comments down below. Otherwise, like, share, subscribe, you know that stuff we ask you to do. Thank you so much for watching, and catch me down here at the beach again next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.